All right, thank you for that introduction. And we're going to cover here the new laws that took effect in at beginning January 1 of this year. They were passed last year in 2023, but they go into effect now. And we're going to take a look at both the statutes and case law affecting associations. Okay, the first one to take that affects associations deals with virtual meetings. This is actually a good piece of legislation which allows associations now to hold their meetings virtually without the requirement of a physical location. What's required in order to do that is that the notice must include instructions for how to get into the meeting. It must provide information on who to call for technical assistance if you're having trouble getting into the meeting. And it must provide a phone option because not everyone has necessarily a webcam and is able to log in for the video portion, but they can call in. So as long as you've got a phone option, then that satisfies the requirement. And one other requirement is that boards must take roll call votes if they're holding their meetings virtually. So that meaning, how does each person vote? Adrian Adams, yes. Bill Smith, no. And record that way. That's so that people who are not watching virtually but through video, but are on the phone, can actually hear who is voting and how they're voting. So this is actually a good piece of legislation that went into effect January 1. There's an exception to this, and that is if in an annual meeting or ballots are being counted, they're required to have a physical location. Now, what's unclear is that can the inspector be remote with members observing on screen, or does the inspector have to be at that physical location? The statute's not clear. And we're taking the position that the inspector can also be remote. And that's because it would increase the cost significantly for a lot of associations if the inspector has to be physically located at on site. So this is something that you'll want to talk to your legal counsel and take a position on how you want to handle these kinds of situations with remote ballot counting. Okay, the next one deals with quorum. And again, another good piece of legislation. A lot of associations, especially older ones with older documents, don't provide for reduced quorums. So if they don't meet quorum at the first meeting, it would reduce automatically to a lower quorum requirement at an adjourned meeting. They don't have that option, which means that if they require 50% of the membership to be present, they might never be able to make quorum. So what the legislature did was they said that it would reduce automatically to 20%. So the association, the board can adjourn the meeting to a later date, has to be adjourned at least 20 days, and then the quorum drops to 20%. Now, newer sets of association documents, CC&R bylaws, might require or might provide that it would reduce to 15%. This is especially true for larger associations. I've seen it in the 1,000+ associations where it drops to 15%. If that's the case, then you follow the bylaws. You don't have to go to 20% and then go down to 15% with a third adjourned meeting. It just automatically drops to the 15%. Now, there's a note here. That is, it did not apply to recall elections. So quorum requirements do not drop automatically by this statute if it's a recall election. Okay, the next one deals with term limits. And this was an issue that came up a few years ago when there was a large change in how elections were handled, and term limits got knocked out by that piece of legislation. They were put back in and then again modified by AB 1764, which states that associations must disqualify candidates who served a maximum number of terms, or they cease to be a member. So if they cease to be a member, they're no longer qualified and they're disqualified from running again. And they also included in this that if you disqualify a nominee, the directors must comply with the same requirements. Not sure why they put this in, but if, for example, an existing board member has served 3 terms, is now on his 4th term, and the association adopts a term limit requirement, they aren't automatically knocked off the board. It's only when their term ends and they become a candidate, because it states clearly you have to disqualify candidates. So if he wants to become a candidate when his term ends, he can't, he or she. So they have to step down for whatever the term limits are required. Usually that's for 1 year. Okay, note here, and that is, this can create a problem if you don't have anybody willing to step up and volunteer to serve on the board. So if, let's say, 3 terms are up out of a 5-member board and they're turned out, they have to step down, but no one willing to volunteer to serve on the board. Now you've only got 2 directors out of 5. So what we're recommending is that you amend your bylaws, and we're doing this with all the bylaws that we're amending or restating. And that is, if there are no volunteers, then the term limit is waived and the director can continue to serve on the board. If you have volunteers, then the term limit goes into effect and the person has to step down. The next one deals with ADUs. This is a problem piece of legislation. Legislature is trying to force affordable housing across the state, and by forcing it into homeowner associations as well. And what they're doing here is that they've already stated that owners, and this is in planned developments, not condominium associations. So planned developments, owners are allowed to add an ADU to their backyard. So this is going to be a small unit, usually about 800 square feet or less. And here, this piece of legislation says that the owner can turn it into a condominium and sell it. So you can have a condominium now sitting in the backyard, owned, being bought and sold, and they can sell it separately from the main dwelling. So it's now becomes a separate piece of property within the association. And if it's converted to a condo, the condo owner does not become a member of the association, which means you can't charge them assessments. So you've got a condo owner sitting in the association not paying assessments. So we're recommending a couple of things here, and that is to amend your CC&Rs and require that both, one, that the board and the membership approve the ADU before it can be converted to a condominium. That's one of the provisions in the statute, is that it can be converted to a condominium with association approval, but they didn't define what that meant. And so if a board of directors said, we approve, that may constitute association approval. In order to avoid problems like that, this is where you want the membership involved as well. So we're recommending that their bylaws be amended to require that both the board and the membership approve the conversion to a condominium. And also recommend that you include in the amendment that if the condo owner then becomes a member and must pay assessments and comply with the CC&Rs. And then also require, one third point is that require that the owner that wants to convert his ADU into a condominium pay for any expenses incurred by the association in making that unit part of the association. So I think with those safeguards in place, it's unlikely, one, that ADUs will be converted to condominiums and planned developments, But if they do, then you've got the proper steps in order to make them a part of the membership and a dues paying member required to follow the CC&Rs. Okay, the next one is also a unfortunate piece of legislation. Again, the legislature is trying to force affordable housing everywhere across the board, including in homeowner associations. And so what they're doing is they're requiring in many of the new associations being built that a portion of the units be affordable housing. So what they're doing with this piece of legislation is now limiting dues increases that board can impose on the membership, but only as to the affordable housing portion. So they're going to limit that to 5% of cost of living, not to exceed 10% greater than the preceding regular assessment. So what's going to happen here is, especially when there's inflation, is that there's going to be dues increases in order to try and keep up with inflation, and the regular owners will get regular dues increases. The affordable housing owners will have limited dues increases, which will increase the gap between the regular owners and those with limited income. And the effect is going to be a widening gap over time, which is going to basically shift the burden onto everyone else to subsidize the affordable housing units. So, and they define affordable housing to mean a unit occupied by not just lower, but moderate income households. So this is going to be, I think, going to create a problem as time goes on. And hopefully it will be addressed at some point in the future, but I'm afraid it won't. Okay, the next one deals with lender guidelines. As we know from prior webinars, that there have been Fannie Mae guidelines that were imposed in order to address building inspections, deferred maintenance, and structural safety issues because of the collapse of the Champlain Towers. And so they're doing it through the lender requirements. So lenders have to ask all of these questions of association boards about their existing maintenance and structural safety issues and those kinds of things. And if they don't answer the questions or give answers that they don't like, they will not become eligible for loans. So it's their attempt in order to force associations to take care of maintenance, which is a good, actually a good intention. And association boards, it's their obligation to maintain the common areas properly. And so many of them have deferred maintenance and deferred and deferred and deferred. And it's creating problems in the associations, and they're improperly funded for reserves. So this is going to, with the new lender guidelines, force many associations to start addressing these issues, which is a good thing. Probably one that's going to be coming up fairly quickly is the issues involving balcony inspections. If they do a balcony inspection and discover that there are problems, they have to disclose that to lenders, which means then the association may cease to become eligible for loans. So just boards need to be aware, they need to start taking care of maintenance issues in their associations. This is another bill that's kind of interesting, dealing with watering of lawns. And it's going to, starting in 1929, 5 years from now, require that associations cease using potable water, which is drinking water, on non-functional turf. And then they define non-functional turf. And basically it's turf that's not being used for recreational purposes or any other purposes. It's generally fenced off, or it may be in parking areas where it's just decorative, not being used, and they can no longer water it with drinking water. So it has to they have to either use non-potable water or change out the landscaping so it doesn't require water. So I'm interested to see where this is going to go because some of it's not clearly defined. And I expect we'll see some more clear guidelines come out over the next 4 years and how to deal with this issue. Okay, there was a change in small claims court limits, so they've increased from $5,000 to $6,250 for companies. So the association, if it wants to bring an action against an owner in small claims, they're limited to $6,250. Whereas a natural person is not limited to that. They can go up to $12,500. So they can sue the association for $12,500. Association can only sue the owner for $6,250. It would have been better if they had kept them even so that they could deal with assessment issues and small claims instead of having to go to larger court, where it's going to cost the owner more money to defend themselves. But this is what the legislature decided. They're also they raised the limit in limited jurisdiction cases to 35,000. That's not going to affect most associations. It's going to be the small claims issues that will impact them. Okay, this is another problematic piece of regulation. It's on the federal level, and it's the Corporate Transparency Act. And it says that for those corporations, and almost all associations are corporations now, with less than $5 million in assets and fewer than 20 employees, have to annually file a report with the let's see, trying to look to see what the organization is. Well, you'll know what it is. We'll have it on our website as well. And what they're looking for is small corporations that are being used to launder money and finance terrorism. And clearly that has nothing to do with homeowner associations. And CAI is working, trying and get homeowner associations exempted from this. But beginning January 2025, you have to file a report, which means you have to start the reporting process now, or keeping the information to look to file the report. So they're going to want to know the business name, so the name of your association, the name of all your directors, their birth dates, their home addresses, driver's license number, state ID, or passport, and then identify the person with substantial control. So it's unclear, does that mean all the directors, or does it mean the treasurer who's in charge of the finances? Does it mean the management company who's handling those finances on behalf of the association? So there's a lot of unknowns here, and hopefully CAI will be successful in getting associations exempted from this. So undoubtedly there will be more reporting on this as we go through the year on whether the associations are going to have to file these reports or not. Okay, now we get to some of the cases that were interesting that affect associations. This one is the Alta Del Mar case. And the decision in that case dealt with emails between directors between meetings. And the LNSU number 1 is an owner using his company name, sued the association because directors had been exchanging emails between meetings. And the court looked at the statute and arrived at the conclusion that directors are allowed to discuss business by email between meetings. And they looked at the definitions, and what they arrived at, what they decided as a court, was that board meetings are defined as in-person gatherings of a quorum of directors for the purpose of talking about and taking action on associated business. So as long as the board doesn't take any action, they can discuss issues between meetings, which will better prepare them for the meeting, and then have open discussion in the meetings before the membership and vote on issues in front of the membership. The decision in this case also dealt with unanimous consent, because it was always unclear in the statute for unanimous consent. you need unanimous consent of all the directors in order to hold a meeting by email, which means they're going to make a decision by email. And then it was unclear, does that decision also have to be by unanimous consent? The court said, no, it doesn't. So unanimous consent to hold the meeting by email, but then majority decision in order, whatever that decision, that issue of business that needs to be taken care of. What was also interesting is that this is a published case, which means it can be cited and relied upon as an authority. There was a challenge to this, a request that this case be decertified, that it not be published. And the decision by the court was no, it's not going to be decertified. And so it now stands as law that can be cited, case law that can be cited. Okay, the next case, Lake Lindero versus Barone. And this is also kind of interesting because a lot of associations, well, I don't know a lot, but there are some associations, like Lindero in particular, that had amended their bylaws to require a majority of members' approval in order to recall directors. So a majority of the entire membership had to approve the recall of directors, not a majority of quorum. Well, the Corporations Code 7222 provides that it's a majority once a quorum has been achieved. So once you reach quorum, it's only a majority of that number. And so there's a conflict now between the statute and the bylaws. And the court came down on the side of the statute. So meaning that the Corporations Code prevails and it's a majority of quorum once quorum has been achieved. And what that means that these sets of bylaws that you can't make it more difficult to recall a board. So any supermajority or higher requirements than the Corporations Code are invalid in any sets of documents out there dealing with the recall of directors. In this case, this is another case, Takaguchi versus Venetian Condominiums. Another interesting case. And here you had an association, fairly large association, but they only had 3 directors. That was all that was required. So and of those 3 directors, father owned 18 units, was elected to the board. There apparently some vacancy on the board, and they appointed his son to serve on the board. So you've got father and son controlling a 3-member board. And what they were doing to retain power is not holding elections. And that was happening because, as is typical, not enough people voted, you couldn't reach quorum. And so they would then decide, we didn't meet quorum, election's over, and we're still on the board. Well, there was a push to remove them from the board by electing new directors at the next annual meeting. So 166 ballots were cast. They needed 188. So the members at the meeting adjourned the meeting to a later date, and the quorum then dropped to 33%, which meant then they would have quorum and they would have new election and vote the father and son out of office. Well, the board, father and son, overruled and declared that the election had failed, and therefore they stayed in office. And so what was the ruling in this case? The court found that the adjournment was valid, quorum had been reduced, and that therefore they did have quorum, and they ordered that the ballots be counted. So this was a good outcome. And it's interesting that you would have some people who are determined to stay in power in a volunteer position. Well, here the board or the association was successful in voting them out of office. Okay, this is an issue dealing with disabled parking. This comes up more often than we would like. We do see a fair number of these come up where an owner is disabled, and so they want parking space either closer to an elevator or closer to their unit. So here, the association, in this case, Fairleigh Hayes versus White Sales, was not required to create an accessible parking space in the parking structure. So the question is, why not? Because that's a fairly common request, and associations are required to accommodate that request. Well, the reason why is the board didn't have authority to reassign deeded spaces. They were deeded. So the individual owners owned their spaces, and the association could not order them to give up their space in order for this disabled person to have a space closer to the elevator. Okay, so what they could have assigned, and they were willing to do, was to use an accessible space outside the garage, the parking structure, in exchange for one of the spaces, which the owner was not willing to give up. So this is fairly common that if you want a space, if you're disabled and you want space closer to the elevator, to give up your existing space. And this was the appropriate, I think, a fairly good decision in this case. Unfortunately, it's an unpublished decision. Okay, here's another one dealing with disabled parking. Here, the association refused to assign an available parking space to a paraplegic with a wheelchair accessible minivan. And in this case, the court ruled not just against the association, but also the management company, found both of them liable for not having accommodated the request. And this is, again, where if a request is being made of a board of directors dealing with parking, boards should immediately talk to legal counsel and not just make a decision, no, we're not going to give it, or we're going to force an owner to give up a space and find themselves entangled in litigation. They need to get good legal counsel and make a proper decision at the front end in order to not end up in court. Because the courts, I can tell you, are very friendly toward disabled and lean in their direction when making their decisions. Okay, here we have Ladera Ranch versus Tinsley. And the Tinsley made some architectural changes without getting approval. The association cited him. He refused to cooperate. The association sued him, and they won in court. So now this issue deals with attorney's fees. The law firm had 11 lawyers assigned on the case. They billed $600,000 in legal fees, and the trial court awarded the full amount against the owner, and so on behalf of the association. Well, the owner appealed, and the Court of Appeal looked at it, and they found that the award was excessive for rules violation. So a small rules violation should not have cost this much money in order to get to a decision in court. So they ordered it to go back to the lower court and to reconsider the award of attorney's fees. So again, and what we're seeing is a lot of legal fees are spinning out of control. And here, the court is trying to get these back under control. So putting 11 lawyers on a case dealing with an architectural violation is a bit excessive. And boards want to be careful in their law firm, their legal counsel, and how they handle these kinds of issues. Okay, here's another unpublished case, but also interesting in that you've got an owner who started engaging in an escalating pattern of photographing and video recording the neighbor's family to document potential rules violations, not actual rules violations, but potential ones. So the owner sued and sought a restraining order and argued that they were harassing and stalking them by watching them, photographing them, watching their every move. Well, the defendant argued that the neighbors lacked a right to privacy in public spaces. So they step outside of their door, it's no longer public, and they can be photographed. Well, the court looked at that and said, it's a bit much, what you're doing, and they do have a right not to be harassed. So even though they don't have a right of expectation in a public area, they do have a right not to be harassed and stalked. And so the court ruled in favor of the neighbors and against the owner who was photographing their every move. So if this issue, and where this is important for boards of directors, if an owner comes to the boards, I'm being harassed. You've got to do something with this, with a neighbor who's stalking our every move. And typically we'll say, well, you can go to court for restraining order. But here, the association is possible to be sued because they weren't dealing with the nuisance provision of the CC&Rs. So at least a demand letter to the owner saying, stop with the harassment, stop with the photographing, the stalking, and at least make that attempt. And if they refuse, then fine. Now, I don't know that the board is obligated to actually file a lawsuit. That would be on the individual owner, the neighbor to neighbor issue on getting a restraining order. But the association should at least go the steps of making demand to stop, holding a hearing, and imposing fines on the owner who is violating the CC&Rs by harassing the owner. And this would be under the nuisance provision of the CC&Rs. Okay, so if you want to look at more depth into these the bills and the cases, we have them listed on our website. And if you go to the home page of the website, you'll see there a tab that says new laws. If you click on it, it will take you to the new section, the new laws, and you can look at the bills. We have them linked, so you can click on the links. We have them summarized, but you can go straight to the bill and read the bills. The same thing is true with the cases. We have those linked as well. You can pull up the case and read the case in its entirety if you wish. If you have questions about the bills that we've covered, the new statutes in any of the cases, please submit those to HOA organizers, and they'll get them to me. What I can do then is respond back through HOA organizers on any questions. Now, this isn't like open season for any question that you have. Keep it to the new statutes and the new cases that we covered here. So thank you very much for attending, for observing this, for watching the section of the webinar.